now cross to our National Assembly correspondent in Abuja, Sagir Ibrahim, who was at plenary earlier in the day to provide a recap of events as they unfold. Also joining me is a legal practitioner, Liborous Oshoma. Thank you, gentlemen, for being here. Sagir, it's been a very busy day for you. Talk to us about the bone of contention still, even with this seeming listening to the people by the parliament.
Well, good evening, Felicity. For the National Assembly, the Senate particularly, it was straight-jacketed in the sense that plenary commenced in earnest, I think around 12:32 or thereabouts, and right when the president of the Senate was taking the votes and proceedings of the previous session was when the chief whip of the Senate, Senator Tahir Monguno, had raised the point of order through which he raised a motion to amend, he raised the point of order to sort of provide for an amendment to the last decision regarding the particular section of contention, and that clause 60 sub 3, which ought to have provided for a lot of what is causing the rancor, transmission of election results in real time. Now, the amendment that had been put out by the Senate had adopted what was in the previous act of 2022, which had caused for a lot of individuals within and across Nigeria, as well as civil society organizations, to hit the street, expecting that at a time like this, in this century, at least to a large extent, we should be able to provide for electronic transmission of results, but not just that, to also see that, the electoral umpire, which is INEC, uses electronic transmission of results as the basis for collation, not just as an option. So Senator Tahir Monguno had raised that point of order to ensure that the previous decision of the Senate be rescinded, first of all, then amended to capture what they feel would be what Nigerians had so yearned for. And so we saw the amendment go on. That amendment went on to mention that there would be a provision of transmission of results electronically, however, with a caveat that should, in case electronic transmission of results is not possible in areas where that's a black spot for whether it's lack of network connectivity or whatever the case, they revert back to collating results manually using the Form EC8A form itself. And of course, that raised other concerns because the expectation was that Nigerians were going to see the addition of that real-time clause added to the amendment, but that was not added. Other issues that were raised by many Nigerians who have been watching this issue closely relate also to time frame for the conduct of the elections. It was initially 360 days. We are seeing an amendment that has reduced that to 180 days, but sadly nothing was mentioned around or about the issue of time frame for the election. Now, it was at the phase where the amendment was done that Senator Ibrahim had raised a point of order coming under Order 72, declaring a division and also insisting that the votes be taken by lawmakers individually. Now, the expectation, a rowdy session erupted. What we expected would go on next was to see lawmakers stand up one by one to deliver their individual vote for or against the amendments to the Electoral Act. But sadly, we were not even given an opportunity to do that because shortly after the session was calmed, Senator Ibrahim withdrew his order. So what we saw then afterwards was a smooth passage of the amendment, after which the plenary continued.
All right, quickly, in 30 seconds, because we need to go to Liborous, do you expect protesters to continue with this? Because it doesn't seem they're satisfied going by the information flying around.
I mean, Felicity, they've started expressing disappointment. The expectations are still very high. A lot of Nigerians do not feel that these lawmakers have scratched the surface of what they had expected to see in terms of amendment of the act of the law. So I wouldn't be surprised if I see Nigerians still hit the street because I would say that widely, even from interviews granted so far, they seem to not be satisfied. Felicity.
All right, Sagir, thank you very much for all the coverage. Do catch your rest after a long day. Let's go now to Liborous. Emergency session was called. One would think it's a response to the protest that has transpired. But there is a proviso to this seeming U-turn. Does the proviso making EC8A, the primary source in cases of transmission failure, preserve the manual collation under a different label, as is being said, or this provision is just being proactive, so to say?
You can say to some extent, depending on the side of the pendulum that you're standing, it is convenient to say that there are some places where it will be impossible to transmit results electronically because of network failure in those areas. Like some areas in the Northeast, you can say that, like I said. But at the same time, it depends on what you want to achieve. For some time now, we also see the telcos.
Definition for failure due to communication. How is that defined in law? Who determines what transmission is impossible? And does that discretion create room for abuse, really?
There's no definition. That definition is at the discretion of the electoral umpire. The Act does not define that. And when there is no definition in the Act, just like the Supreme Court has said in interpreting the emergency power of the president as spelled out in Section 305, he says that, the president shall use extraordinary measures. And since extraordinary measures is not defined anywhere in the Constitution, the Supreme Court has said extraordinary measures can mean suspension of a governor duly elected in a democracy, duly elected with the president. So in the same way, when failure to transmit is not defined anywhere, what it means, that's why I asked, if the failure is man-made, if the failure is as a result of a glitch created or frustrations created by, even the umpire or by the actors themselves, what the law says is, there is a failure. And that failure is not defined. The failure can be genuine, it can be man-made, it can be orchestrated, it can be manipulated, provided there is failure. Failure is failure. So what that means is I can decide to create failure in the entire country and make it impossible for INEC to transmit results electronically. Once that happens, certainly they are going to go manual. But if we were in a society, if we were in a society where there was trust, the people trust the lawmakers, certainly ordinarily this wouldn't be a problem, because to every law there is a proviso, because it is not cast in stone, it is not one straight jacket. There can be unforeseen circumstances. But because of the failure of trust on the side of the lawmakers and on the side of the leaders, and that's why people are saying, you know what, we don't even want a proviso.
All right, quickly, before we go, staying with proviso, if results uploaded to IReV conflict with a manually collected EC8A produced under this condition, which is more likely to prevail in court based on existing electoral case law?
No, what had happened now is that transmission is now part of the electoral law, unlike before when it was INEC guideline. Now that it is part of the electoral law, if the result is transmitted electronically where it is possible, certainly that result transmitted electronically will take precedence over the manual one, because the law allows for electronic transmission. Unlike before, there was no provision in Electoral Act for that. That was why before then it is the manual Form EC8A, and that was why the Supreme Court, Yetola and INEC said the IReV was just a viewing portal. But now it is no longer just a viewing portal, because the law, Section 60(3), has made provision for result to be transmitted to it. If all results are transmitted to it successfully and there is no glitch, then certainly you don't need manual Form EC8A. That's what it means, unlike what we had before.
Liborous, thank you very much for speaking with us.
My pleasure.